We will call the next case, People versus Edwards. Okay, you're ready to go. This is a 20-minute argument, and you may, well, no, you can't reserve any time. You have 20 minutes.
You don't have to use it all since the other side waived,
Yeah.
but
Thank
you
you.
have 20 minutes.
Thank you, Chief Justice, Your Honors. Good afternoon. My name is Matt Monahan. Along with co-counsel, I represent Mr. Edwards. May it please the Court. The problems in this case are the same problems that my co-counsel has identified, and we seek the same remedy. Before diving in, I'd like to think about solutions in line, Justice Bernstein, with the practical reality here. What I think helps illuminate the separation of powers problem is the way the funding could be. It's a public benefit to have a court system. We all benefit from it, even if we don't use it. And some level of statewide funding helps ensure that everybody pays for that benefit. In addition, Michigan's got a long history of that local plus statewide cooperation when it comes to funding public goods. So another way to do the cost collection piece, which I think Justice Sauer gets to your question, is a user fee schedule. And some of this comes from the Trial Court Funding Commission that you mentioned. It's referenced in the amicus presentation from the DJC. But the idea behind the uniform user fee schedule goes to the real distinction here, which is a user fee versus a tax. Every user pays so the government can recover some of its costs when the government provides a service. I think motion filing fees come to mind. Or as you think about the business of a court, there's writ fees, PPO, different cases, writs, PPOs, TROs, motions. They require different things from the courts. They require different costs. What the TCFC recommends, and I think is consistent with how this funding could go, is that there's a study and we determine what those actual costs are. That it's not about salaries, benefits, the costs of the building, things of that nature. It's what's the cost of the operation of the court. But that also speaks to another piece of a user fee, which it kind of goes to regulation, not revenue. This is a part of that Cameron test. If I know that I'm representing somebody and I'm going to file motions, if it's $100 a motion, maybe that third motion to reconsider, maybe I think differently. And I think that's the idea of a user fee. You can use the public good, you can use the service, and that's great. But there may be a need for you to help the government recover some of the costs in providing that service. We all have waivers for indigent clients too, which also makes sense, and that's incorporated there. But
I'm waiting for a constitutional argument to come up.
Yes,
somewhere in there.
I can see I'm wading into policy. I think the constitutional
The
argument
legislature's down the street.
Here it is, right. I'll go there next. The judges cannot assess taxes, but the judges can collect user fees. That's I think the key distinction in this case. What's that? I'm sorry?
Can they collect costs?
If the cost
Can
is
they
a
collect
user
fines?
fee,
I don't like Cameron, I'll just be honest with you. They put you in a box, it's a fee, it's a fee or it's a tax, it's a fee or a tax. I don't think that we're limited to those two options.
I think for the purposes of these two, the presentation of the issue, separation of powers, respectfully, yes. I think, but that limit from Cameron isn't as problematic as it might sound. Because if the cost that we're talking about, if the actual cost is a user fee, and so go to, I think you mentioned the CVRA, okay? The Constitution in this state, it requires some things of courts when there's a victim of a crime. And a victim of a crime is tied to someone convicted of a crime. So if the state wants to attach a fee, a user fee, to a judgment of sentence, it's going to be covering the notice provision that comes out of this, the crime victims' rights provision in our Constitution, the security provision, the providing of security that's in there, the ability to speak, that goes to some of the costs that are at a resentencing. If what the CVRA is doing is allowing the government to recover the costs from the users who are most, the relevant group of users. That's the other kind of problem with the way it's currently set. The users that are funding the system here are those convicted of a crime. And they're paying for a benefit that goes to everybody. But there's a whole lot more users. It's sort of like if you lose a divorce case, then you pay for the whole divorce system. That's kind of the same idea. It doesn't make a ton of sense as a user fee. It starts to look like a tax because you aren't paying for your use. You're not paying for the benefit that you're getting. You're paying for everybody else's benefit. And I think that's what distinguishes some of these flat fee questions from the tax issue. If we're talking about a funding structure that is designed at having individuals, and not every individual that uses the system, if we're talking about them raising the revenue above the cost of a service, then we're talking about taxation. And that's what I think Houseman gets at. The judges don't do that. The parallel to Houseman is tighter, is tight. Houseman was about a public health initiative. I know it's a drain commissioner. But
Are all fines taxes?
no, Your Honor. No, I think fines and taxes can be different, but there's sort of some overlap. And a tax as punishment, whether or not it may look like a fine or be a fine, really isn't before this court, but they can be different. So I think the way to think about that may be going back to user fee and tax. If someone, so I think the DV, there's different statutes that impose monetary penalties based on a conviction. And those different penalties are tied to different aspects of the use of that system. So when it comes to the tax user fee analysis, there's ways to distinguish those penal fines that prevent a separation of powers ruling here from bringing the sky down, really. That's the difference. These different monetary penalties have different groups of users, and especially when you're talking about a tie to the actual government service provided, you're really outside of taxation at that point. Cost recovery is a meaningful constitutional distinction for the separation of powers analysis. I think the other part of it is fines are proportionate. I mean, that's the teaching of the excessive fines clause. I think the Antolovich case out of the Court of Appeals gets at this, but certainly Timms out of the Supreme Court. If the fine imposed has to run through the same proportionality test that the rest of a sentence runs through. But taxes are not proportionate. That's the real difference. And I think the problem with the scheme that you have here, where at sentencing, the judge is thinking about salaries and benefits, and that's just not part of what a criminal sentence is. It's about the circumstances of the individual. It's about moral culpability. It's about the circumstances of the offense. So that's another way to distinguish taxes and fines. It's along that proportionality axis, if that
And
makes
counsel, it does
sense.
put a burden on the defendant, right? Like, it's so often what we hear from a policy perspective, since, a lot of the argument that we're hearing does have a policy perspective, is that it does put a real burden on folks, right? That this is something that basically, can be very difficult for people to get out from under.
Absolutely. I think it's not in the briefing, but it is in the record here. It took Mr. Edwards years to pay $1,300. Many of us may be able to write a check and cover $1,300 in a short period, but yeah, that's a burden. That's a burden. And the other, I think, the other point that I want to pivot to that kind of relates to burden is on the due process piece. Justice Welch, you mentioned zeroing it out. Essentially, if the district judges banded together and they said, go down to zero. And I think that goes to the facial challenge here. If it's a zero assessment, well, I take that back. This really goes to both issues, separation of powers and due process. I think there's still a constitutional violation such that every application of the statute is still a violation. You're still talking about a judicial tax assessment. Is it a harmful constitutional violation? Maybe not. But it's a judge deciding, is the budget good enough today? Or is this a break to the individual? It's really hard to know. And I think that speaks to both I kind of blended separation of powers and due process there. Let me step back. The zeroing out, to the extent it's an application of the statute, is still a tax assessment. It's just zero, and therefore harmless. On the due process side, the statute doesn't allow consideration of individuality. It doesn't allow indigency to factor in or ability to pay. So we don't know what's driving the zeroing out.
But wouldn't the zeroing out show they weren't influenced? Is there an appearance of impropriety if it's at zero?
I think this is some of the challenges of the objective test. It's that we don't know. That the bias is sort of what's private, but because you're sitting there facing the court, are you the lucky five who get the break? Or, is there some individualized consideration here such that we don't worry about the bias? Are you getting zero because the revenue is there? Or are you getting zero because the judge knows you have no ability to pay? I think another way to maybe think about this is if it's a revenue generation scheme, and if the only way to make the revenue generation scheme work is to charge nothing, something's wrong with that scheme. That seems to sort of fall apart. And I think maybe another way to think about it in line there is a zero application, a zero assessment may not be an application of the statute.
What do you make of the Attorney General's point that they raise of not really being able to distinguish the fact that we elect judges in this state and that they fundraise for campaigns to get the job or to keep the job? Is that, so that there has to be some distinction between, some sort of, something more than a de minimis amount of implicit bias, I guess, is okay.
I think,
Hasn't there kind of been a determination made when they say the maximum amount that you can accept as a campaign contribution is $7,150, that amount is presumed not to be influential? And when we look at the costs here, isn't it something less than that, such that it should be presumed not to be influential in the determinations made by the court?
Of course, that's an individual cost per judge, right? We're talking about a whole institution and a whole statewide, right? So yes, $1,200 is a lot less than perhaps the contribution, limit, but $1,200 across in every district court across the state is a big difference, right?
I think what makes the sentencing scheme different from the election cases, so Caperton, the sentencing cases, I'm thinking Ward, Dugan, and Toomey here, and Caliste and Kane, although it's more revenue generation in the criminal context. What distinguishes them is the dual role, that the judge is acting as a judge, making a judicial decision. But at the same time, they're tasked with this financial obligation, this interest in the court's fiscal health. And I think that's distinct from the election cases where you're talking about an individual actor's individual vote in an individual case. The dual role does work for Toomey and Ward. I think this case is closest to Ward, where you've got that interest on the judge's behalf to make sure that the fiscal health of the court is sound. That doesn't feel similar to me to the election situation. I think another thought is there's guardrails around elections that prevent some of the concern about biases. There's recusal rules. There's all sorts of ways that I think elections work differently than generating revenue off of monetary penalties at sentencing. That make Caperton seem different from Ward, Toomey, and Dugan and address what the Attorney General is getting at there. I hope that's helpful. The other part about the due process argument here, I think that is relevant. Mr. Edwards was convicted by a jury. His convictions are not at issue on this appeal. They were affirmed by the Court of Appeals, I think, 7 years ago. This is really just a resentencing appeal. So he's not ever challenging what happened at the trial or what may have been in the judge's head at trial. And I think that's a really hard standard when it comes to objective evidence, because it almost starts to feel conspiratorial in a way that we don't need to worry about with this case. Because the district judge amicus are talking about a really specific, and I think co-counsel gets this, it's sort of acute pressure that happens at that moment when the deprivation of property occurs, which is different from anything relating to the trial and the conviction process. That's my best shot at distinguishing that out. It may not be persuasive, but I think that's
Well, first
a
of all,
distinguisher
our
here.
ruling, of course, will apply to more than just your client's case. In his situation, it's nice that he's not challenging his trial. But you know, if we decide that this statute makes it so judges can't be fair and impartial, you know, that has structural implications. And other enterprising lawyers and their clients might present us with the argument that infected earlier decisions leading up to convictions. And so we should answer to them how?
That there still needs to be evidence, even of objective bias. I mean, if the evidence isn't there.
Not if it's structural, you don't have to show prejudice, do you?
But you need to show the violation. To show the violation, you need evidence of actual bias.
You're saying the judge is only partial when it comes to assessing costs. Up until that point, he's completely, or she is completely fair and impartial and completely neutral on whether there's a conviction. But at the moment of conviction, the judge seizes on that and then becomes partial and unfair.
I think this goes back to the language of the statute. That the language of the statute directs a decision that happens after conviction is entered. After somebody who has pled has kind of come into the court and admitted the facts that
But the judge,
permits
it's not
the
like the
conviction.
judge is dealing with one case a decade. I mean, the judge is dealing with dozens of cases every day. So you're saying for all the cases at an earlier stage of the case, the notion of raising money, the judge doesn't think about that or forgets about it? Or what is it that the judge thinks about it?
I think it really does go to the acute
What
point.
makes the switch go off at sentencing that the judge is able to somehow keep these feelings in check all the way up until that point, the ones that then, you know, come out with such force when he's or she is selecting the appropriate cause?
The plain language of the statute. That's when that decision is put before the decision maker, and it's about assessing this court cost, which if you're really serious, if it's seriously about court costs, you really don't even know what your costs are until it's all said and done. And that's what's different about this statute. Court costs is, in a civil case, it's the last thing you do. You've fought over everything, and then, you know, the parties present what it costs to have the motions and the transcriptions and all of that. That's what this statute is after. It's, okay, now that every other decision is done, now you get to that. And I think it's really hard to tease out of that evidence that this cost determination, which is really a tax, is sort of lurking without any evidence of lurking throughout the entire trial. So that would go to the way this is distinguished just to that deprivation of property at the end.
So circle back to where you started on the user fee. And if it's uniform, somehow that takes that bias or potential bias that's there throughout the whole case, that would take that away?
I think the uniformity of I think that goes to Amicus's point. If there's a bias in that situation, it wouldn't be with the judge. That would be in a different place. But no, I think the uniformity would take the conflict. That's the Trial Court Funding Commission's recommendation. That does remove the conflict because it's uniform across the state and it's based on what it costs to do what happened in court. Recovery, it's about cost recovery again. That's the key there. Whatever this case, you know, whatever special parts of this case required the government to outlay, the government was able to recover. And I think that's where the uniformity would do work on the due process side. I see that I'm coming close to out of time. Unless this court has further questions, we'd ask to remand with, really for the remedy that the Attorney General has offered. It's in our brief for vacate the court cost and reimburse.
Thank you. The case
Thank
will
you.
be submitted.